Barrister Salman Akram Raja, first of all, I would like to thank you for joining us on Dawn English. My first question would be that, the demand to form a full court, a lot is being said about it. We see a huge divide in this. PTI feels that there is no need for a full court. However, it is at the behest of the Chief Justice of Pakistan whether a full court should be formed for this case or not. Do you feel that the case merits for a full court?
Well, it's hard to say, but I think in the circumstances, there is no harm in a larger bench, at least maybe 9 judges. And the primary reason for me for saying that is that there is a judgment in 2015 of 17 judges of the Supreme Court. In that judgment, 8 judges signed a separate note in which they've made certain observations about the powers of the party head in terms of Article 63A. Now, in my view, those observations are incorrect. They were not really dealing with this question of the division of powers between the parliamentary party and the party head. But in a very general sort of way, they seem to have made the party head all powerful. Now, if that judgment is to be revisited, then you need a bench larger than 8, I would say. Even though it's not the order of the court, it is one of the judgments of the court and not the majority judgment. Nevertheless,
Right.
8 honorable judges have signed that note, and therefore propriety would demand that a larger bench hear that matter. So that is one reason for my favoring a larger bench, at least 9 judges, if not full court. And the full court at the moment, mind you, is 13 judges. So that's, I think, one good reason for proceeding with a much larger bench. Other than that, the review against the 63A decision is still pending on the presidential reference. There, 5 judges decided the matter. So again, that review has to go before at least 5 judges. And if that happens, again, we need a larger bench if the review is to be heard along with this matter, which has arisen out of the ruling of the Deputy Speaker of the Punjab Assembly. And there is a link, because if that review is accepted, then the votes of the 25 PTI dissidents who voted on the 16th of April would have to be counted if the decision of the majority in the presidential reference were to be overturned in a review. Then those votes would be counted. And Mr. Hamza Shahbaz Sharif would stand elected, duly elected, as of the 16th of April 2022. So that is an important matter. Then the appeals against the Election Commission order, which de-seated 25 PTI dissidents, is also, I think, relevant, because if those dissidents are restored, then there was no need for the 17th July by-elections, and those dissidents would come back and their votes would come back, and we would go back to where we were on the 16th of April. So there's a bunch of matters which are interconnected. And I think a larger bench is not a bad idea at all in the circumstances.
But do you feel, Barrister Salman Akram Raja, the review that you're talking about, which is pending before the Supreme Court, regarding Article 63A presidential reference, the decision that was given. Today, during the proceeding, the question, it was a question or probably a remark passed by one of the judges of the 3-member bench, that, if you are relying that on the Supreme Court's decision by rejecting these 10 votes of PMLQ means that you have accepted the decision on Article 63A on the presidential reference that was given by the Honorable Supreme Court. My question to you is, until the review takes place, is the Supreme Court's decision on Article 63A binding till the time the review is taking place and whatever final decision comes on them?
You see, there is no estoppel against the law. So what the PML N side can say is that, look, there is a decision of the Supreme Court in the field which says that those votes are not to be counted. We've relied on that decision. If you uphold that decision in review, then the situation will remain as it is. But if our review is accepted, or if the review petitions are accepted, then the 25 votes which were disregarded, which were cast on the 16th of April, those votes would come back. So either way, the situation changes. So all of this is interlinked.
Okay, so it is interlinked, and it is indeed important once and for all that 63A is interpreted in final and full form, so that then there are no questions raised, right?
Quite right.
So do you feel
Absolutely.
that, okay, there is a governance crisis now in Punjab, which is existing since past, I mean, since the time this present government, came into power. Do you feel that all these bunch of petitions should be first heard, a final decision to be taken, and then probably the PMLQ's petition could be more valid, rather than, just listening to PMLQ's petition right now, whether a full court listens to it or probably a larger bench?
No, I think they all have to be heard together now. The PMLQ petition, now depends to a large extent on the earlier decisions. All of them have become interlinked, and the facts in the PMLQ petition arising out of the Deputy Speaker's order actually, places everything in proper perspective. A lot of these earlier decisions are academic in nature. There was, the reference, for instance, there was no real dispute before the Supreme Court. It's essentially an academic decision. And that is what an advisory opinion in a reference sent by the president is. So now we have a real world situation where the distinction between the parliamentary party and the party head is of utmost importance. The decision of the Election Commission is a very badly written decision. It again does not really make the distinction between the parliamentary party and the party head. So there's been a lot of loose writing in the past, which I think now needs to be kind of examined and made more precise.
All right. There is one question that on the political front, if you come to see that the press conference that was done today earlier by the present government, its allied parties, the party in opposition, that's Pakistan Tehreek-e-Insaf, they say it amounts to pressurizing the judiciary. Do you really feel this is the case?
Well, yes, and that was clearly the intent. I mean, they were addressing the judiciary, they were making demands, they were saying that certain courses of action would not be acceptable if the three-member bench continues to hear the matter. There will be no confidence in the outcome. So, yes, it clearly was an attempt to influence the decision as regards the formation of the bench. So, that is correct. But all sides have been doing that. It's not that PTI or its leadership has not been doing that. This has kind of become now the norm that political leaders do speak out in political gatherings and press conferences with a view to impacting judicial outcomes. So that has been a fairly consistent practice now for the last at least few years.
Thank you so much for joining us,
Welcome.
Barrister Saab. Take care, and that's all for now.